So yesterday on Court TV, we got a tip from our friend Ian Friedman. He's been on the show a ton of times. A great attorney from Cleveland, Ohio. That there was a criminal trial with a jury being selected in a case, and I was like, really? And so we started watching it, and I was surprised first of all, but then kind of encouraged that okay, our system of justice might try to get those wheels spinning again by figuring out a way. In the midst of this lockdown and the coronavirus, to come up with a way to socially distance from each other, pick a jury, and have a criminal jury trial. Well, then I tuned in today, and this happened.
Good morning, ladies and gentlemen. As you can see, we don't have defense counsel and defendant present. And I apologize for the delay in getting these proceedings started. We brought you in here earlier, and I apologize for making you wait, but we've been having discussions on the record with counsel. The defendant was present for that. And in light of some of the events that took place yesterday that were a little out of the ordinary, as well as some other developments that occurred last night, part of our discussion was the fact that both the state and the defendant don't believe that we're in a position at this point, with everything that's happened, to give either side a fair trial. So we are going to kick this trial for a couple of weeks, but we're going to start with a fresh pool of jurors. So when I excuse you today, you folks will no longer be obligated to appear for this case. As far as what your obligations as jurors will be in the future, you'll be thrown back in the pool if, toward the end of your term, we run short of jurors. Because of this situation, we're going to be bringing more jurors in than normal the next time around. We're going to do 3 sessions of voir dire instead of the 2 we tried this time, because we were teetering on the edge of running out of a sufficient number of jurors after the attorneys exercised their peremptories. My normal, as I think I said to most of you, I can't recall since we did 2 sessions whether everybody heard this or not, but my normal policy is to seat the 12 jurors and have 2 alternates. If all the peremptory challenges got exercised that were available for exercise, we would have had 12 jurors left, and that would have been it. We would have had no alternates, so if somebody did get sick in the process of the trial, we'd have to declare a mistrial because we couldn't proceed. That's getting a little too close to the edge for comfort. So we're going to bring in more jurors next time, so as the attrition occurs, hopefully we'll have a few more left over by the time we get to the peremptory challenges by counsel.
And it wasn't just the attrition of the jurors. There was a problem with the defendant in the case as well. At the end of the day yesterday, he was taken out of the courtroom. So what happened, right? What happened? Let's bring in Adam Stone, who is the attorney for the defendant, Seth Whited, in the case. Also with us, our friend Ian Friedman, who gave us the hot tip and was at the courtroom today at the courthouse. Adam, let me begin with you. What happened?
Well, in these circumstances, my client, I was voir diring the second set of jurors, and I started to notice that my client was breathing heavily. He became emotional, started crying, which isn't necessarily uncommon, but as he started crying and his breathing became irregular, the next thing I know, he's tearing his mask off, and he had already shown some symptoms of COVID-19. And he's beginning to shake. And I motioned to my paralegal, we need to get him out of the courtroom. Judge stopped the proceedings, allowed us to get him out of the courtroom. We took him to a separate room. EMS was called. He was taken out on a stretcher and taken to University Hospital Samaritan there in Ashland, and ultimately quarantined on suspect of COVID-19.
Okay, so then today happened, right? And so Was the trial supposed to continue this morning, or did it end with the illness or whatever happened to your client in the courtroom yesterday while he was wearing the mask?
The trial was scheduled to continue. My client was ordered, despite having medical documentation showing that he was showing symptoms of COVID-19. He had actually taken a test, but that test showed up initially negative. However, they were afraid of a false negative in light of his temperature, his fever, things of that nature. Judge wanted him in court today. We had him at court, but I was not comfortable for a whole heck of a lot of reasons to not go forward under those circumstances.
And okay, Ian, thanks for the tip, first of all, appreciate it.
Sure.
But can we have trials with social distancing and people wearing masks? And I noticed the jury is sitting in the gallery and they're streaming it because all the spectators can watch it online because it's a public trial rather than being able to get into the courtroom. What are your concerns here and your thoughts about going forward in the world that we live in now?
But Vinny, I understand it's a difficult position right now. The courts have to get running again, but they've got to keep people safe. At the same time, they also have to honor defendants' rights. I mean, it's very tough to do right now. But what I saw at the court today just makes me think about what the judge just said to the jury when he said things were a little out of the ordinary. That's probably the understatement of the century. There was nothing ordinary about this. This case should not have gone forward for a number of reasons. Adam could not properly investigate the case. You can't go knocking on witnesses' doors during the stay-at-home orders to investigate. He's got a mask on. How does he reach over and lean over and talk to his client with a mask on in the court? How do you give documents to a witness? How close can you get to a witness? The list goes on and on and on. And it seems that this judge was in an awful big rush to get this done so that other judges could see how it's done and open their courts. They've got it backwards. They have to ask themselves, how do we keep people safe, and how do we address all the nuances of trial before we get to the courtroom? It shouldn't be that Adam and his client and the jurors, the court staff, and everyone are the test subjects. They should have figured this out beforehand, and then you open the court. This was backwards. It was inappropriate. And that's why we're getting involved now, all the various bar associations across the country, because this is much bigger than this. If the court is trying to use this as a model for other courts, they need to understand that this is an example of what not to do. And so it's incumbent upon us to now use this as a opportunity to educate the other courts.
Yeah, I mean, I was very surprised when we got the tip that this was happening, right? I was like, really? But I was encouraged. I'm like, okay, maybe they figured this whole thing out. And then again, I tune in today and I see an empty courtroom and then the judge comes in. So, Adam, I mean, were you pushing for a speedy trial? Were prosecutors chomping at the bit? We got to try this case.
No.
How was it that everyone ended up with a trial date?
This was our fourth continuance. This case, my client was on bond. He had waived speedy trial more than once in this case. We asked around April 7th in a motion to continue that COVID be taken into account, especially with respect to social distancing and all of those types of requirements. And I completely agree with Attorney Friedman with respect to what I experienced in that courtroom. But I was willing to give it a chance after the Supreme Court turned down my writ of mandamus. I challenged Judge Forstaffel's courtroom preparations and accommodations to the Ohio Supreme Court, and ultimately that was dismissed, and we were in a position where we had to go forward. And I was sitting at counsel table.
Let me ask you one other question here, Adam.
Sure.
Let me ask you about the jurors, right? Because to me, that was the biggest issue I was thinking about, jurors having to come down there. So
Yes.
How were they reacting to this whole process? Were any of them sick?
We really had a mixed bag, and I think that's what you're going to see across the country. We had some older folks who were genuinely terrified, and they were really upset to have to be there. Even some of our younger people, there was a very, very nice young man juror seated at the back, and he is visibly shaking. I could not see him. The prosecutor actually had to inform the judge that this gentleman was visibly shaking. And at that point, I stood up to look and confirmed that, in fact, he was shaking. And once it was addressed, it was determined that it was anxiety as a result of the entire environment, all of the circumstances that we were imposing upon this citizen who could otherwise serve on a jury. I mean, it was not fair.
Yeah, again, they tried. It didn't work. And as you're telling me, Ian, you got the defense bar around the country is going to get together on this. So we're going to stay on top of it. Ian, please keep in contact with us on any developments that you hear and what's happening nationwide so we can report it here. Adam Stone, Ian Friedman, out in Ohio tonight. Thanks so much, guys.
Thanks,
Thank you
Vinny.
so much.